Thank you, everybody, for joining us for this extremely interesting session around why and contracts of employment are essential to your business. And yes, they are. I know personally, I did live it firsthand in my own small business with my 3 employees. It was a disaster because I did not have a contract of employment. And now I am an employee. So there you go. So I will let our professionals take you through this today as well. So we are very lucky to have 2 excellent employment lawyers with us today. Now, this session is brought to you by HR Covered. My name is Mark. I'm VP of Sales with HR Covered, so we can take care of everything HR for your organization. And then we also have 2 employment lawyers from HRC Law, who are basically the home of unlimited legal advice, which we can get onto a bit later today as well. Now, for some housekeeping, if you look at your screen, so you have the Zoom link, depending on how it's set up. So you should be able to see at the bottom of it, you see the chat. So you can use the chat if you want. However, we do prefer that you use a Q&A. So there is Q&A a bit further. So if your screen is not wide enough, you may not see it. So if you make it a little bit wider, you should be able to see Q&A, kind of 2 bubbles towards the right hand of your screen. So if you use that to ask questions throughout the event, I will actually be monitoring all the questions. So you might see me look over here, look over there. I have a few screens. I'm always paying attention to everything that's on there. And if the questions are relevant to what we're talking about, we'll ask them right away if I get to them on time. If not, we'll ask them at the end of our session. Then, of course, you can always raise your hand as well if you have any additional questions. Washroom, I hope that everybody knows where they are. So if you do use them, get there safely. So, all right, let's start with our session without any further ado. So, of course, it would not be in a meeting with employment lawyers unless we had disclaimers. So we do have disclaimers at the beginning of our session. So first, today's presentation is not intended to be legal advice. This is a high-level overview. So the terms of any employment contract are dependent on the specific situation that you're in. So always consult with a professional lawyer if you have any questions. And when we say qualified lawyer, if I have employment law questions, I want to go to an employment lawyer, maybe not a real estate lawyer. They are very good at what they do, but make sure you go to an employment lawyer for employment law questions. And employment law changes quickly, especially these days. So as such, your best course of action today may not be the best course of action tomorrow. So always communicate with professionals for those things. Now, when it comes to the professionals that we're going to be talking with and actually are going to be talking to us today, the first one that I'll introduce you to is Anatoly Dvorkin. So Anatoly is a small business owner. I actually founded 2 law firms with some partners as well. So absolutely tremendous. And then he has 18 years of experience in various areas of the law. Over the past 10 years, he focused almost exclusively around employment law. And you have his contact information over here as well. So he'll be able to answer any questions that you might have as well. Then we also have another fantastic employment lawyer with us today as well. Her name is Lubisa Durlovskova. No, sorry, Lubisa. Sorry. So Lubisa.
Okay, that was
Lubisa. So
close,
I'll stick
Mark.
with Lubisa. Durlovska. So thank you. And so 10 years of practicing employment law in Canada in different provinces as well, from hiring to firing and everything in between, human rights issues, investigations, advising on employment issues in buy and sell agreements as well, or different corporate transactions. And we also have her contact information over here at the bottom if you want to get a hold of her. Now, our agenda for today's session, yes, we're going to go over contracts, but we're going to go over the importance of an actual written employment contract, practical tips for ensuring the contract is actually enforceable, because that's also extremely important. We're going to go through drafting tips, and we'll also have a high-level review of a checklist to help you know what kind of clauses you can actually have in a typical agreement. And then at the end of this, we'll have our Q&A as well. So I'll pass the floor to Anatoly for the first slides and the first topics.
Okay, hi everybody. Thank you so much for joining us. I'm really pleased that you have. I know everyone's busy and it's the middle of the day or the beginning of the day for some people, and you all have things you need to be doing. So we're going to try to make this really worth your while and make it a quick, hard-hitting webinar that informs you about employment contracts and primarily about why they're so important. So I'd like to start with what most people who are business owners or who are in charge of a business or even a not-for-profit think about all the time, and that is how can they either make more money or save themselves money. Well, an employment contract, a written employment contract that is enforceable and that has valid termination clauses in it will save you a lot of money. Now, before I sort of get into the meat of the presentation, I just want to tell you a quick story from earlier today. So I was, sorry, my screen just went dark. I hope it didn't for everybody else. Excuse me while I try to refresh my screen. I wrote a LinkedIn post about the presentation that we were doing today, and I don't know if can everyone still hear me? Can someone, one of the panelists?
We
okay,
got you.
Perfect. Is the screen still visible? Because it went dark on my computer for some reason.
Yeah, we see it.
Okay. I'm going to try to refresh it.
And I think I saw the post you're talking about, Anatoly. Was it talking about the fact that employment contracts are too expensive for a small business? Was that the one
It
you were?
it was, yes. So sorry again, I'm having some technical difficulties with, there it is. So yes, that's exactly right, Mark. So I had written a post about this webinar and just talking about a little bit about what we were going to be speaking about today. And somebody made a comment and said, well, that's really great, but you know, the reason why a lot of businesses don't have professionally done written employment contracts is because they can't afford it. And I replied, and what I basically said at the end of the day is, in my opinion, Canadian small businesses can't afford not to. And you're going to see why really, really quickly in this presentation. The other thing that we'll get into a little bit later is that it's true that with the traditional model that law firms have employed over the course of years, billable hours, a lot of legal services were really unaffordable. That's one of the reasons why I created HRC Law, and we've tried to address that, and we're going to talk a little bit about that at the end of the presentation. So not only you know, do I believe that it's no longer the case that it's unaffordable for small businesses in Canada to get professionally written employment contracts, it's also, I think, not something that you can say that you can't afford to do. It's something that, in my view, you can't afford not to do. And the primary reason for that is when it comes to terminations, and we're going to get into terminations fairly heavily in just a moment. Now, of course, employment contracts are not just about terminations. And when you hire someone, you're probably not thinking about how you're going to fire them and when you're going to fire them. But of course, that's the reality of life, that, you know, employment relationships don't last forever. But employment contracts also have other utility, and primarily it is there to create clarity in the relationship between the employer and the employee. And the more clarity there is, the less chance there is of a dispute, and the less chance there is of a dispute, the less chance there is that you're going to land in litigation with your employee. So that makes for happier employees and happier employers. It also gives you increased flexibility as an organization and increases the chances of your policies being enforceable. So COVID really brought this to light, because obviously during COVID, a lot of companies and organizations were temporarily laying off their employees. Now, without getting too deep into this, when you temporarily lay off an employee, although it may be permitted under the provincial legislation, at common law, which is judge-made law, that has always resulted in what's known as a constructive dismissal. And you can think of a constructive dismissal almost like a wrongful dismissal. And so that is always the case unless you have a written employment contract where the employee specifically agrees that the employer can temporarily lay off the employee if they want to, and without that being a constructive dismissal. But without a clause in a written employment contract that says that, that temporary layoff is really a termination and can lead to a constructive dismissal lawsuit. And the other thing that you should really note about the utility of employment contracts, aside from being able to save you tons of money, is that the more important the role of the employee, I think the more important it is that they have a contract. So with really important employees, you might have some restrictive covenants that you want to put in. So confidentiality clauses, non-solicitation clauses, even non-competition clauses, which a lot of people know in Ontario, you can no longer use non-competition clauses except for with some really high-level C-suite employees. The bonus structure should be laid out in a written employment agreement so there isn't conflict about when bonuses are due, when they're not due, how they're paid. And different types of compensation aside from salary, so compensation through shares and options should all be set out in an employment contract if that's part of the person's compensation package. But now I'd really like to get into what I believe is the primary reason that every organization needs to have all their employees on an employment contract, a written employment contract. And to understand this, you also need to understand how terminations work in Canada for all provincially regulated employees. This will not apply to federally regulated employees, but most employees in Canada are in fact provincially regulated. And for provincially regulated employees, you do not need a reason to fire an employee. A lot of employers think that you have to come up with a reason. In other words, they think, oh, well, I need to say that this employee wasn't doing a good job, or I need to say that the employee was difficult to get along with, or was, doing bad things with their computer, or whatever the case is. The truth of the matter is you don't need a reason to fire an employee. But if you do give a reason, it must be legal, which means that you cannot terminate an employee or in fact refuse to hire an employee for grounds that are protected by, let's say, the Ontario Human Rights Code or similar legislation in other provinces. So we're talking about things like age, ancestry, color, race, citizenship, etc. But the primary point I want to drive home here, and this you'll see why this becomes important in a minute, is that you do not have to have a reason to fire an employee. You can fire employees without cause. Now, to determine how this all works, you have to go through a bit of an analysis. And here's a little decision chart that I created to help people with this analysis. So the first thing you're going to do is you're going to say, is there a written employment contract? Now let's go down the branch that says no. If there's not a written employment contract, when you terminate an employee, that means that the common law applies. Now, I said before, common law is judge-made law, and I'm going to say just for now that you do not want to end up in that column. You do not want the common law to apply, and I will explain why in just a few minutes. Now, if you go down the yes side, so there is a written employment contract, you have to ask yourself another question, or maybe you have to ask an employment lawyer this question. Is the contract generally enforceable? And Lubisa is going to talk about what might make a contract generally enforceable. And does it have a valid termination clause? Now, if the answer to either of those questions is no, then you're right back to where you started when you didn't have a written employment contract and the common law applies. And again, you don't want to be there. If the answer is yes, then you're in luck, because then all you have to do when you terminate an employee is provide them with the minimum standards stipulated in the Employment Standards Act or the equivalent provincial legislation in your province. So a lot of people, when I talk about these things, they'll say, well, what about cause though? What if I have cause? What if the employee did something bad, or they're just a bad employee and their work is not up to par? What if I have cause? Doesn't that change the equation? So for a lot of people don't know this, but if you believe you have cause and you can prove that in court if you're challenged, you still will have to pay ESA minimums to the employee. The only time that you can avoid paying ESA minimums is when certain conditions or criteria exist. And in Ontario, there's some specific language in the Employment Standards Act that says that where an employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So if that's the case, and you can establish that and maintain that if challenged, then you don't have to pay the employee their ESA minimums on termination. But that's really the only scenario when you don't. But if what they did does not amount to that, does not live up to that standard, then you still have to pay them the ESA minimum, even if you have cause. And everyone should be aware that cause is a very high threshold and it's hard to establish. It is considered by the courts to be the capital punishment of employment law. So it really is sort of the very last step that an organization should be taking. So talking about cause a little bit more, oftentimes we're asked, well, is it worth it? Like, should we allege cause if we really think we have it? And the answer most often is no. So this is especially the case if there is a valid employment agreement in place with a valid termination clause, because then what you can do is you can terminate the employee without cause, and you're only going to be obligated to pay them in accordance with the minimum standards set out in the provincial legislation. The only exceptions to, should you allege cause, well, these aren't the only exceptions, but these are some of the exceptions. If the conduct is especially egregious, and some examples might be theft, violence, harassment, or in the situation where for the company, what's more important to them is setting a precedent in terms of, for their workforce than financial liability. But if what you're worried about is financial liability on termination, then you really have to think twice about alleging cause and doing a termination with cause. So in summary, to summarize those ideas, if you have an enforceable written employment agreement that contains a valid termination clause, then an employer in Ontario can limit termination pay to 8 weeks. And that's if the employee has been with the company for 8 years or more and not have to worry about alleging cause. So let's see how this plays out when you're talking about two situations. One, with an enforceable written employment agreement containing a valid termination clause, and on the other side, without an enforceable written employment agreement. So if you have an enforceable written employment agreement with a valid termination clause that limits the employee to their ESA minimums on termination, then what you're on the hook for as the employer is 1 week for each year of service, up to a maximum of 8 weeks. So even if the employee has been with your company or your organization for 30 years, they cannot get more than 8 weeks of notice or pay in lieu of notice. Okay. Now, in certain situations, depending on the size of the company and the size of the payroll, you might also have to pay severance. And severance is equal to 1 week also for each year of service. Now, this would be on top of the notice that you've paid. And that's up to a maximum of 26 weeks. So in the worst case situation, you've got 26 weeks of severance and 8 weeks of notice or pay in lieu of notice. Now, let's contrast that with if you have no written employment agreement with an enforceable termination clause. Then you're going to be paying based on the common law. And the current maximum is 24 months or 26 months in exceptional circumstances. And the calculation of the loss incurred during the notice period will include all aspects of the employee's compensation. So that will include things like RRSP contributions and bonuses and anything else, car allowance, anything else that the employee was entitled to. So we can see really quickly, just in real numbers, what the difference might be. So let's look at a real life example. Okay, so in a recent decision of the Ontario Court of Appeal, the 2022 decision, we had a plaintiff, so an employee. She was a 58-year-old woman at the time of termination, and she sued her former employer for wrongful dismissal. The employer, at the time that they dismissed her, just gave her her ESA minimums. Okay, and they thought that they could get away with that. Now, unfortunately for the employer, they did not have a written employment agreement that dealt with the employee's entitlement upon termination, which means right away the employee is entitled to common law losses. Okay, so damages under the common law. So and the employer's lawyers agreed that she was entitled to reasonable common law notice. So the question became, well, how much is she entitled to? And because of her age and her length of service and her lack of transferable skills, this was one of those situations where the court actually said, you know what, there's exceptional circumstances here. And this employee is entitled to 26 months of pay in lieu of notice. So let's look at the numbers. So the court said she's entitled to 26 months of pay. That equaled almost $139,000. When you do the math, that turns out to about $1,243 a week. Okay, so that's what her salary was. Now, if you look at if they had a proper contract in place with a proper termination clause, they would have had to pay $32,316.80 for a whopping difference of $96,701.80. I mean, that is a huge number that they could have avoided if they had a proper contract in place. And this isn't the largest number I've seen. I mean, I think Lubisa is going to share an example later with an even larger number. So the point being, you can literally save yourself hundreds of thousands of dollars without exaggeration, and that's with one employee, just by having a proper contract in place. I personally think that's mind-blowing, and it's incredible to me when people say that they just can't afford to put in a proper contract. It is not, I mean, even if you were paying a lawyer on an hourly basis, and that lawyer was charging a really high rate, you might pay, $5,000 or something like that to get a properly written contract. And I think that's maybe a little bit on the pricier side. But if someone were to tell you that you could pay $5,000 and save yourself $100,000, I think you would take that deal every single time. So I just want to drive the point home that it's not that you can't afford a proper contract. I think you can't afford not to have a proper contract. And I think at this stage, I'm turning it over to Lubisa.
Right before you turn it over to Lubisa, sorry, everybody, I got a call from my daughter. So you shared a lot of good, really important information. I think you're right. People probably cannot afford not to have a proper contract of employment. And in that particular situation, we talked about severance. Now, in what situation, because I mean, we hear the word severance thrown out all the time around, I have 3 employees, I don't owe them severance. I have 25 employees, our payroll is too low, we don't owe them severance. Now, what exactly is the proper meaning of severance and how does it apply?
Yeah, it's a really great question. So the definition when severance applies is actually provided right in the legislation in the Ontario Employment Standards Act and in other provincial equivalent legislation. So in Ontario, you have to have a global payroll of $2.5 million or more, or have 50 or more employees. I believe that those are the criteria for when you owe severance. So if you don't meet that criteria, then you don't owe severance under the ESA, meaning that you're only going to then be obligated for the notice period or pay in lieu of notice.
Thank you, Anatoly. And then I think sometimes we hear, and probably a lot of people use some sort of severance pay calculator that also apparently applies to me if I work for a small business that has a payroll under 2.5 million. Now, is that basically the word that is not properly used, and it's just basically common law entitlement?
Yes, that's exactly what those calculators are calculating. They're basically those. If you see an online calculator and it's called a severance calculator or something like that, what that calculator is basically saying, let's assume that this person is entitled to common law damages because there is no proper contract in place, or for some other reason, and so therefore let's calculate their so-called severance based on severance entitlement based on the common law. So really, they're not using and to be used under the Employment Standards Act. They're using it as a general title to on termination. So I like to basically say, I like to call that termination entitlement as opposed to severance, just to keep the two terms separate. But you're absolutely right. A lot of times those are called severance calculators, and people think of it as I was given a severance package, because severance really just means that the relationship has been severed. So the question that is that what does the employer owe the employee upon severance of the relationship? And when I say severance of the relationship, I mean a severance that is instigated by the employer, not by the employee. So that doesn't apply to resignations. So I hope that answers the question with respect to severance.
Does it also answer the second question as well? So fantastic. Thank you, Anatoly.
No problem.
Okay, thank you, Anatoly. That was a great analysis. And thank you, Mark, for the great intro. You did get my name right in the end, so I appreciate that. I want to talk to you for my part about how to have an enforceable contract. So it's not enough that employers have a contract. And I mean, anyone can go on Google, type in the word employment contract, get themselves an employment agreement from someone that looks like it might fit your purposes, and then you give that to your employee. And what that really does is it gives employers a false sense of security in their contract, and that they have a contract, and so they're protected, and maybe now they can terminate their employees by providing those Employment Standards Act minimums that Anatoly was talking about versus the maximums, which is the common law, right? So I'm going to talk to you about how to make sure that those contracts are in fact enforceable. Okay, so we'll talk about offer and acceptance, consideration, which is a very big one, certainty of terms, and then how to comply with the minimum standards. So in order to make a valid contract, it's not always just about the contents of the contract. We also have to think about the form of the contract. We have to think about how that contract is presented and how it's accepted. So we have to think about making sure that the contract is signed voluntarily, so that there's no pressure or coercion on the part of the employer to have the employee sign. So and pressure and coercion can be very subtle. It's not always a gun to the head situation, right? If we have an employee or an employer who sits down their employee in the middle of the day in an office, presents a 20-page document saying, hey, here's your new employment contract, sign it, and then you can go back to work. That's not necessarily, you might not necessarily think of that as coercion, but it might be in that situation because the employee thinks that they have no choice, right? And they haven't really been given enough time to consider the contract, to think about the language that's being used, what it means for them, and maybe to get advice on the contract from their spouse, their accountant, their lawyer, whoever they go to for these types of situations. So as a rule of thumb, what I suggest to my clients is giving at least 5 days, 5 business days, so a week, with the contract, so that the employee has enough time to really consider what it means for them, and to ask any questions, and also to negotiate. And employers are often scared of negotiation, but they shouldn't be. I welcome negotiation. What that means is that the employee has had a chance to look at the contract. It means that they are engaging with the contract. And quite frankly, just because the employee is asking for something extra doesn't mean that the employer has to give it. So you as the employer can always say no to anything above and beyond what you're already giving. And by that, I just mean what you might already be giving for consideration. So don't be afraid of negotiation, welcome it, and you can shoot it down if you have to. And the last way that a contract can be invalidated, that can make a difference between a valid contract and an invalid contract, in other words, is consideration. So consideration is sort of a really big trap for employers, mostly because it's not a very well known concept, and employers don't know what it means. If I said, have you given consideration for this contract to one of my clients who is new to me, then they might say, well, what is that? Yeah, I gave them enough time. Sure, that's consideration. But that's not what it is. And I'll tell you what it does mean. So in order to have a valid contract, each party to the contract has to give something of value to the other in order for there to be like a meeting of the minds, right? So there must be a mutual benefit to both parties in order for them to enter into this agreement. Now, a contract without consideration, in legalese, in a very fancy Latin legal word, is void ab initio. And what that means is that it's void from the start, from the beginning. So it means that this contract is it's like it doesn't exist, right? So the fact that you went online, the fact that you spent money, even maybe going to a lawyer to get the contract, if you don't provide proper consideration for that contract, that is a waste of time, a waste of money, because that contract will be invalid. And this concept of consideration is different for new employees versus existing employees, in that for new employees, if you give them the contract prior to them starting their position, then the consideration for the job, the consideration is the job in exchange for them doing the services and providing the deliverables that they are going to provide. So this is if the contract comes before the job. Now, say that you intended to give a contract at the start of the relationship, but you just didn't get around to it, or you couldn't, or whatever happened. And now you have an existing employee who's now working and getting paid, and things have been chugging along. You've been going for months, maybe years without a contract, but now you decide you want to protect yourself because of all of the reasons Anatoly said. You can't just present a contract to an existing employee and say, sign it, and have the continued employment be the consideration for signing that contract. In other words, you need fresh consideration, something extra above and beyond what the employee is already getting, in order for there to be sufficient consideration for the employer and the employee to enter into a new agreement. Now, the consideration, and this is a big question everyone asks, well, what do I have to give my employee in order for me to be able to give consideration, for there to be consideration at law? And the answer is that it can be anything. So in the eyes of the law, anything from $1 to $1 million will do just fine. But what I want to point out is that giving an employee $1 in exchange for signing a contract that is not necessarily in their best interest, but more in your best interest, might not be enough to induce them to sign. So if you say, I'm going to give you $1 in exchange for giving up all of your common law rights and providing me with a non-solicitation clause, maybe a non-competition clause if you're in another province, confidentiality clauses, so all of these things that are beneficial to me, I want to get those for $1, right? So that's not going to be necessarily enough of an inducement for the employee to sign the contract. So definitely something to think about. Another question that I get often is how to present this, or what kind of, how to give the consideration, what form of consideration, and really it can be anything. You can ask employees to sign based on giving everybody equal consideration. So the same amount of money for everybody. You can ask people to sign a contract based on a calculation or a formula for how to do it. So there's various ways to do that. And here's a real life example of someone who got themselves into trouble, who relied on a contract that they thought was valid, but ended up not being valid. Mark, you have a question.
I have a question. So we have a question in the Q&A, and it's actually quite relevant to, and I don't know if you're going to touch on this, I don't remember from the presentation, but the question is, if we provide someone with consideration, and let's say consideration is not enticing the employee enough to sign on the dotted line of that new contract of employment. Now, what can the employer do if they say no to sign the contract of employment?
Right. So you can't force anybody to sign anything, right? So that's why it's important to be able to induce that employee to sign. And if they don't, then there are other avenues to pursue to try and get that employee to sign the contract. You can try increasing the inducement or changing the terms, asking, what is it about this contract that you don't like? Maybe we can negotiate. Or at the end of the day, if that is not an option, then a termination might be in their future, right? Or asking the employee to sign the contract. And if they don't, then they will be terminated. So you're kind of giving an ultimatum to get to where you want to be. So that's an option, not always the best option. We don't want to use the stick. Mark has heard me use this this terminology before. There's the carrot and then there's the stick, right? Providing adequate consideration as an inducement is the carrot. And if the employee is not going to accept that, then we have the other side of the coin, which is the stick, which is, unfortunately, if you're not going to sign this contract, if you're not willing to work for me under these circumstances, then we have to end our relationship, right? Does that answer it?
Then it does. And then basically from that standpoint, what we've learned from Anatoly before is if we don't have a properly drafted contract and then we want them to sign a new contract to take them away from common law, now I'm assuming that the notice period that we'll give them will have to be based on common law and not based on the employment standards in our province.
Absolutely, yes. So in order to affect that termination, to get there, you do have to give common law notice. Or pay in lieu of notice, right? And what you decide to do will depend on the circumstances, on your business, on the employee. There's a lot of factors to take into consideration, but absolutely, when we have someone without a contract, we have to think in terms of the common law, which is about 1 month of notice or pay in lieu of notice, up to a maximum of 24, 26. We've seen as high as 30 months of notice, right? So just to get back to this example of how an employer got burned by not giving consideration. So Empire Life Insurance decided to hire Mr. Singh. And before they did, they gave him an offer letter, and it very simply stated his position, his salary, the start date, and then it said that he will receive a formal letter of contract to follow, which is fantastic. But that formal letter and contract followed on the day that he started work. So he had already started working. And Mr. Singh, being a smart guy, said, I can't sign this today. I have to take this away and think about it and review it, and I'll get back to you. And he did that. And eventually he signed it 5 months later. And down the line, maybe, I think in this case, it was maybe 11 months or so, down the line, the employer decided they don't need Mr. Singh's services anymore, and they decided to terminate him based on that formal contract that he signed 5 months in. And based on the termination provisions there, they gave him 2 weeks of notice. Mr. Singh was not happy with that, and he sued this company. And in the end, what happened is that the judge said that there was no consideration given for the formal offer, even though it was mentioned in that original sort of very informal contract. They said, no, Mr. Singh was working under that initial written contract, that very basic contract that says, here's your position, here's your salary, and here's your start date. And there was no additional consideration given for that formal contract. And so you can't rely on that. And the common law now applies, right? So this employer learned, unfortunately, a really hard lesson about consideration, and they're not the only one. This is not a unique case. This is not an uncommon case. This happens all the time because employers, business owners, they just don't understand the concept of consideration and how and why it should be given. So my advice and my sort of final piece of advice on that point is, if an employee has started working for you, even if it's on, if it's on day one, they've already started, they've worked for an hour, a minute, you know what I mean? If they've already been there and they've been working, you need to give consideration if you want them to sign anything extra, right? So moving on from that, I want to talk to you about certainty of terms. So now it's about the contents of the contract and not just about the form of the contract or consideration. So terms of an employment contract have to be unambiguous. They have to be clear, understandable, and they can't have multiple meanings, right? That creates ambiguity. And what judges have said is that ambiguous contracts will be interpreted, and here comes another awesome legal word, contra preferentum. And what that means is that the contract will be interpreted against the person who drafted it. And who drafts employment contracts? Employers. So in other words, if there is any uncertainty whatsoever, then we get to a point where that term or that contract will be interpreted in favor of the employee and not the employer. So I noticed that we are running a little bit behind, so I want to move through this really quickly. The last thing I want to talk to you about is contracting out of the legislated minimums. Anatoly talked to you about how every jurisdiction has their own minimum standards for employment, right? And in every other contractual situation, parties are allowed to contract into or out of whatever they want, obviously within reason, within the law. But in employment contracts is actually quite different, because employers are not allowed to contract out of certain legislated minimums. So in Ontario, that's the Employment Standards Act. So if you say to someone, hey, are you okay with me not paying you vacation or me paying you minimum wage? And they say, okay, you can't have a document that says that and override the minimum standards, because then that would create an invalid contract or an invalid provision, right? And so this has wider implications, and we saw this in 2020 with Wakesdale and Swegan, and some of you might have heard this case name because it had a really wide effect in Ontario and elsewhere. Basically, what happened is an employee was terminated based on a termination provision in their contract that essentially said that the employer can terminate by providing them the Employment Standards Act minimums. And then there was another clause, the with cause section, that said that if the employer has just cause to terminate you, then you will not receive any minimum standards. And what the judge said in that case was that doing that, what that does is it attempts to contract out of the Employment Standards Act minimums. And Anatoly mentioned it before, the Employment Standards Act minimum in Ontario for terminating an employee without giving them notice or pay in lieu of notice is very specific. And it's for if the employee is found to be guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and that is not condoned by the employer. So those are very specific words, and the employer has to prove that in order to not give the minimums. But in this case, just by using the word just cause or saying that the employer can terminate for just cause, they invalidated the entire termination section. So not just the section that they were not using to terminate, because this employee was terminated without cause, but the entire termination section was made to be invalid. So you can't pick and choose, in other words, which bits are going to be valid and which bits are not going to be valid. I will pass. I will just briefly say there is a newer case, Henderson and Slavkin, that took that to another level, and in it, the judge invalidated termination provisions based on wording in other sections. And in this case, it was the conflict of interest section and the confidentiality section. So those two clauses had specific wording that tried to contract out of the termination minimums. And it said, in the event of a breach of this clause, your employment will be terminated without notice or compensation in lieu thereof for cause. So they used, now a huge no-no word, the F word of employment law. They used for cause, right? And so what they did by doing that is to invalidate their entire termination clause. And what happens when you invalidate the termination clause, it's as though you don't have a termination clause at all, and now you are relying on the common law. So if we go back to Anatoly's sort of decision tree, essentially you fall on the right side and you're at common law. You don't have a valid termination section. Mark, maybe you can tell me, do we have a lot of questions? Do I have time to go through this fixed term versus indefinite term?
You do have time. We have a few, but you're good.
Okay. So really quickly, this is a really big one for a lot of employers, and a case came to our attention recently that sort of brought this to the forefront again, and that's fixed term versus indefinite term contracts. The difference is that in fixed term contracts, there is a time duration or a project duration. There is a definitive start date and a definitive end date. And in indefinite term contracts, there's a start date, but there is no definitive end date stated. And the end date is going to be the termination, however it happens, whether by resignation, whether for cause, without cause, with notice, without notice, whatever happens, right? Now, I want to flag this, and I want to tell employers to beware the fixed term contract, because it can be tantalizing, because it can sound like a good idea to say, hey, employee, you're only going to be on a fixed term contract, and at the end of that contract, I don't owe you anything, any pay for, for cause or without cause or anything. I just don't have to pay you anything. And the reason why is if you don't have specific wording, if you don't have a properly drafted fixed term contract, it can come back to bite you in the butt, and it could mean that you have to pay out the rest of the term if you end up firing an employee sort of mid-term. And the real life example here is Terrace and the Municipal Infrastructure Group, again, 2022, very recent case. This was a 3-year fixed term contract where the employee was terminated 11 months after they started. And the judge in that case found that the termination provision in the contract was not valid because it had that for cause language versus the willful misconduct language that it should have had. And so without that language and without a mechanism for termination, the judge awarded this employee $500,000 payout for the remainder of the contract. And this was irrespective of the fact that this was a really sophisticated, high-level employee. It was irrespective of the fact that he had legal representation. And what's more, the judge said that that this employee did not have to mitigate their damages. This employee did not have to go out and look for other employment, which would have been the case had he been getting common law damages. In this case, because the contract had a definitive end date, the employer, by terminating early, breached the contract and therefore owed the employee the rest of the term. So that's the kind of situation you might be getting yourself into inadvertently by putting yourself into this fixed term contract situation. So just to sum up quickly, it's not just about having a contract. Having clear terms will matter, not contracting out of the minimums will matter. And maybe that's where an employment lawyer can help you out to figure out what are those minimums, am I trying to contract out of them? And then how you present the contract will matter, and the type of contract you use, whether it's fixed term, indefinite. In some situations, there's a choice between contractor and employee, and oftentimes that's an issue. So if you need assistance, you need to seek that out. So with that, I want to ask, what's in your contract? And here is a quick overview of the employment agreement checklist that we developed with HR Covered. It has sort of all of the provisions that an employment agreement might have. And so if you do have a contract, I encourage you to take out your employment agreements and to look at them and to compare them to this list to see what you do have, what you don't have, and keeping in mind the things that we talked about that can potentially invalidate your contract. Think about whether or not you need to update your contracts. And if you don't have a contract, obviously still look at this employment agreement checklist and try and figure out which of these could be helpful to you to protect your business. Right. So I think I'll end it there. I'll pass it back to Mark. I know I'm over time. I'm sorry.
Because of all my questions, so I keep interrupting. So that's what my wife and my daughter keep telling me as well. So thank you so much for this fantastic information, Anatoly and Luisa. And yes, so everybody, I will actually be personally sending you all an email first to thank you for attending the webinar today, but also with the checklist so that you can actually have it and you can expand it as much as you want. You can actually read everything that's on there. It will be your own checklist. And just so you know, our HRC law right now is really changing the whole employment law world. Not only because we have two fantastic employment lawyers on board, but also because we provide you with unlimited HR and legal advice. So everything around employment law on the legal side is really provided by two professionals. It's unlimited, so you don't have to, not ask them about their kids or if they're doing well or if the family's okay. You're okay, you're not on the clock, so it's really refreshing. You also have access to unlimited contracts of employment. So, and yes, on Anatoly's post earlier today, someone said contracts are too expensive, people just can't afford them for small businesses. Now we're changing that world as well. So you want contracts, you have different positions, you have questions, you have access to two fantastic lawyers that can help you and also create those contracts for you exactly for what you need for your situation and for your employees. Now, unfortunately, sometimes relationship ends as well, and you need to make sure everything is well drafted, everything that's in writing is there to stay, make sure it's done properly. So you have, again, unlimited access to termination letters, and there are absolutely no surprises when it comes to the service. And what we need by that is everything is transparent. You don't actually have to pay a retainer. There's no hourly fees. There's no hidden fees. There's nothing that you're used to as part of a regular or a different law firm that you might have dealt with in the past. So that's really how we're different, is we're making sure that we are here for the local businesses, here to support them, here to make sure that they have a budget for this set aside, and it will never go over that budget for the advice and the documentation they might need when it comes to termination letters and contracts of employment or independent contractor agreements. On top of that, it's also really easy to get in touch with them. So you have access to their emails now, their phone numbers, and we also always give you access to their calendars as well. So you can always book some time to talk to your lawyer directly, and they're always happy to do so. Now, as an exclusive offer for all of you for attending the webinar. So of course, if you're looking to either learn more about, how does this all work and how can it actually work for me in my organization, well, hey, you can have a nice conversation and go over exactly how it works, go into details, and really give you all the information that you might need, answer some of your questions privately as well if you feel that it's better for you. And we'll be offering everybody a complimentary consultation, of course, at no cost, to go over all of your questions, what you have in place now, review good practices, best practices, and potentially make some recommendations as well in terms of where you should be. And then we'll present our service. And if you decide to take advantage of our services, everyone on our call today is also going to receive a free month of the service as well, if they decide, of course, to sign up for our programs. So without further ado, so I know we have a few questions. So Karen, I see you. Norma as well, we see you, Angelo. So we'll get through your questions right away. And we'll start with the first one that I see. So Michael had a bunch of good questions throughout the session as well. A lot of them were answered, I believe. So if there's more questions, Michael, that you have, by all means, please send them in the chat.
Mark, I see sorry to interrupt. I see a question from Michael about a terminated employee's obligation to mitigate damages. So I can tackle that one if that's a good time to do so.
Yes.
So generally speaking, aside from certain situations, one of which Lubisa mentioned in her last discussion of the case that she was talking about with the fixed term contracts, but generally speaking, a terminated employee does have an obligation to mitigate damages. For people who don't know what mitigation of damages means, in the employment world, whether or not there's a written contract in place, just by virtue of having an employment relationship, there is a contract in place, even if there is no written contract in place. And anytime there's a contract in place, the wronged or the party that's been wronged has a duty under contract law to try to minimize their damages. So that's what mitigation of damages means. It's what can I do as the wronged party to make sure that my damages are as small as possible. And in the employment law world, what that means is you have to make bona fide efforts to replace your employment. So you've got to look for another comparable job, a job that matches your skill set, a job that might have a similar salary to what you were getting, and so there is an obligation to do so. And where employees fail to do so, and the employer can prove that in court, then courts will deduct what an employee is owed. So important when, I often do wear two hats. In my other law firm, I sometimes represent employees, and I always tell my employee clients that if they've been terminated and they're in a case against their employer, they have to keep a record of their attempts at mitigating their damages. So, those are things like, where have I sent my resume? Who have I applied to? Have I had any interviews? And just keep a record of their efforts, and that's normally sufficient. But yes, the general answer to that question is there is a duty on a terminated employee to try to mitigate that person's damages.
Thank you, Anatoly.
No problem.
So I'll just click that the answer is done for Michael. So thank you for another great question, Michael. Is the ESA standards clause relevant for lawyers on fee split agreements, since their billings are $0? They would get $0 in any case. Is that correct? Or do we understand the question? I'm not sure.
So I think I understand the question. I believe the question is, the lawyer is not actually getting a salary. So they're being paid basically as a percentage of what they earn what they bill on behalf of the firm. And so let's say they bill $100 and they have a fee splitting arrangement that they get to keep 50%. So they get $50 in that situation. So that's a really good question. Do the ESA standard clauses, termination clauses, are they relevant for lawyers on split fee agreements? They are relevant, but I would assume that there's no one's going to stay in a relationship where their billings are zero. The law firm's not going to keep them, and the lawyer's certainly not going to be able to sustain that lifestyle if they've got no billings. So it's never going to be a situation that they're earning nothing. So they're going to earn something, and then it's a question. The question becomes, well, how do you calculate what they're earning? And then you base the what they're owed based on the calculation of what they're actually earning on average. So that's how that would work. Lubisa, do you have anything to add to that?
Yeah,
it's a bit of a complex situation.
Yeah, that is complex, and I think there is a lot to unpack there, and maybe we need to know a little bit more, and maybe this is more of a contractor, an independent contractor situation versus an employer-employee situation. In an employer-employee situation, regardless of how the employee is paid, whether by commission or by some other means, what has to happen is that, again, those minimum thresholds have to be met. So if you are making zero and therefore getting zero, are you meeting the minimum entitlements to minimum wage? Right, that we have that question. But again, it really depends on how the relationship is structured. And I think that there is maybe a lot more to unpack there, and maybe that warrants maybe reaching out to one of us and talking a little bit more about the specific circumstances of your case.
Thank you both for the answer. And I'll be sure in my, so I'll be sending the email to all attendees. So you'll receive an email from us as well. So if you want to talk to Lubisa or Anatoly, just let me know, and I'll be happy as well, of course, to connect you as well. We have the other question here from Baptiste, who was actually asking, do you need contracts for unionized employees?
I can answer that, certainly. The answer is no. Unionized employees work based on a collective agreement. So when you want to figure out what applies to unionized employees, you have to revert back to the collective agreement. And you can't provide unionized employees with individual contracts. So they bargain collectively. They come sort of as a unit with their own terms. So that's where the rules of the game for them can be found is the collective agreement.
And just to add to that, the other thing that I often find with unionized employees is they are not aware that if there's a dispute with the employer, that they can't simply come to an employment lawyer and say, hey, I want to sue my employer in court. They are often really surprised that they can't do that. And the reason is that there's case law that says that you can't do that. You have to go through your grievance process through the union. The union has to file a grievance, and then you have to get all the way up to an arbitrator's decision. And then if you don't agree with the arbitrator's decision, then you might be able to challenge that in court. But until such time, you actually cannot, you don't have access to the general provincial courts to sue your employer for something that you believe, that you want to sue your employer for. So something that unionized employees are often unaware of, and it's really important to keep in mind, both as an employer, if you're faced with something like that, your employment lawyer will know that, but for an employee, you are kind of stuck with the unionized system that you're in.
Thank you both for this. And question from Sheila, are cost of living or regular raises considered consideration? Do you need a whole new contract when an agency-wide or when agency-wide raises are given?
Anatoly, do you want to take that, or?
I'm not sure I understand the question exactly, but I'll give it a try. So cost of living or regular raises consideration. So if a regular raise is built into an is the question here if the regular raise is sort of built into an existing contract, or just how the employer conducts its business, that every employee gets 3% raise every year or something like that, then I would say that doesn't amount to consideration, because that's something that the employee was going to get anyway. So consideration has to be something on top of what the employee is already entitled to, if that makes sense. So if they're entitled to it already, that's not fresh consideration.
And then if, let's say, we tweak that question a bit and say, let's say that's not the case and it's not part of their contract already, but the organization decides, whether it's yearly or whatever the case might be, to give raises. Now, is that a good time to actually have them sign a new contract of employment that could be refreshed with new terms and up to date?
Yeah, absolutely. So if you decide that you want to give a raise to your workforce or to a specific employee, and you want to want to make that coincide with a new employment agreement, written employment agreement, that would definitely be a good way of doing it. And certainly a raise in that situation could be considered consideration.
Can I just answer? I think that was maybe a two-parter. So do you need a whole new contract when agency-wide raises are given? I would say that you need to review the contract to see if you actually need to give a new contract or not. I would say if there are any issues of validity, any issues of contracting out of minimums, any issues at all with having an invalid termination provision, then yes, you should give a new contract. Or even if those are not the case, I think that reviewing one's contract, employment agreements every now and again is a good practice generally, just because we have these cases coming out like Wakesdale and Swegan that can invalidate contracts at any time. And just because legislation, the minimum standards, they change from time to time. And with COVID, that was happening almost on a weekly basis. So we have to review with fresh eyes every time to figure out if this contract is still valid. So the answer is maybe yes, maybe no, but you have to review it every time to figure out if you should or should not. So even if you do give raises every year, and this is a good time to give the contract, it might be a good idea to give a contract, but it might not if your contract is still valid.
Thank you both for your answers and guidance. And now the question from Angelo, who's about or which is actually about, his understanding is that non-compete agreements are no longer valid due to the latest right to disconnect policy recently passed. Now, is this correct? So I think, and probably a two-parter as well in there for Angelo, is if I had a non-compete clause in my contract that was drafted prior to that passing, is it still enforceable? And then on the other hand, I think non-competes are still enforceable even today for a certain group of people.
Really good question. It's really so first thing I want to explain is the non-compete and the right to disconnect policy are not actually related. So the ban on, and we're talking about Ontario here, new legislation in Ontario. So the ban on non-compete agreements and the right to the requirement to have a right to disconnect policy are not actually the same thing. So let's deal with the non-compete agreements first. So Mark, you're correct. So it's not a complete ban in Ontario on non-compete agreements. There are still exceptions to when you can use one. So in the situation where you're dealing with the sale of a business, you can use a non-compete agreement. And also when you're dealing with the high level, really essential employees like CEOs, presidents, other C-suite employees, you can still have non-compete agreements in place with those employees. Now, aside from those situations, it's correct. Ontario no longer permits non-compete agreements. So if you have a non-compete agreement in your employment contract, it is not going to be enforceable. Now, the truth of the matter is that they were extremely difficult to enforce even before this legislation at common law. So the courts do not like the idea that you're going to restrain someone or make it more difficult for someone to find a replacement job. And so they've never liked non-compete agreements. They had to be extremely limited in order for them to be enforced, both in terms of geographical application and in terms of how long the non-compete agreement would last. And there had to be a really, really valid reason for the non-compete agreement to exist in the first place, for it to have been valid. But with the new legislation, aside from those two exceptions that I mentioned, they are no longer permitted. Now, with the right to disconnect policy, that's a different thing. That is basically a requirement that the Ontario government passed that every employer of a certain size, I believe it's 25 employees or more, must have a right to disconnect policy. It has not stipulated what should be in that policy, but just that there needs to be one.
That makes things so much easier for employers.
Right. Exactly.
Thank you for the detailed answer, Anatoly.
No problem.
And now we have the question from Karen. What if you have a fixed term contract, but the individual continues working past the end date? How does that work?
I can take this one on. So what happens with a fixed term contract that continues past the end date is that you are now in verbal agreement territory. That contract is not necessarily valid anymore. And so you and the employee are working on the basis of a verbal contract. So what I would suggest is providing proper consideration and providing that employee with an indefinite term contract that is terminable, or that you can get out of, that you can terminate by giving the ESA minimums. And then that way you will be protected when it comes to terminating this employee, because it sounds like you had in mind a certain date by which this contract would end, but it extended. So unless you know for certain that this contract will only go to a certain date, then I always recommend contracts that are indefinite term and terminable on the minimums, because like I said, in that case that came out recently, you can really be doing much more damage with a fixed term contract. And I find that a lot of employers think that they can continue giving, let's say 1 year contracts, and they can continue cycling through 1 year contracts, but that doesn't necessarily renew the employee's tenure for any purposes. For the purposes of the Employment Standards Act, that contract continues, that person continues to be an employee, right? And so you have to recognize their tenure for the purposes of termination, for the purposes of giving them vacation time and anything else really that's tied to how long they've worked for you, right? So if an employer thinks that they're doing themselves a favor by doing these cycling through, they're really not. And upon termination, they will end up having to pay the common law, like the maximum, unless those contracts have really good termination provisions. I hope that answered the question.
I think so, and thank you for this, Lovisa, as well. And Karen, if you have more questions about that you'd like to ask, if it was not exactly what you were hoping for, please, there's still a bit of time, so you can always ask another question in the Q&A. Alan, I see your question as well about pricing for services. We can address that later. Essentially, it's always based on the number of employees you have in your organization, and we're priced extremely reasonably as well. So I'll grab a screenshot later as well. I can give you a sense of what that looks like in the email that I'll be sending to everybody. So we'll make sure this is available as well for at least to give you an idea for everybody. Should unionized employees still be required to sign a contract indicating that they are bound by the collective agreement?
So yeah, so that's not necessary. They are deemed to be bound if they are in fact a unionized employee, and there is a collective agreement in place, and they are deemed to be bound by the collective agreement as someone who is part of the unionized workforce.
Thank you, Anatoly.
No problem.
Does any change to an employment agreement for whatever reason, even with changes to employment law, fall under requirements for new considerations and such? That was a question from Alan that we have on there at 3:08 p.m.
If I understand the question correctly, so I think what Alan's asking is if there's a change in law, either because the legislation changes or because, or because there's a new case that comes out that makes your old contract no good. So you need your employee to sign a new contract. Do you still have to give consideration? And the answer is yes. You are asking an employee to sign a new contract. Maybe your old contract was no good because now it doesn't meet the new requirements that a new case has established, but that's not the employee's problem. That's the employer's problem. And the employer does have to offer consideration in order to get the employee to sign, in order for any new contract that the employee signs to be enforceable.
Thank you, Anatoly. And then we have a question here, which is, with everything now online, can we accept an online signed offer from Adobe? In other words, not certified. Would an online signature be considered valid or enforceable?
So yes, it will. I think that with COVID, most things went online. We couldn't do in-person signings of a lot of things. And employment contracts were no exception. There is provision for it in the legislation for accepting electronically signed documents, and there shouldn't be an issue. I think the biggest issue that you will encounter with accepting signed documents is someone saying, well, that wasn't me, I didn't do that, I didn't sign it. So I would just say follow up with an email saying received your signed agreement or whatever it is to get confirmation. That's really all there is to it.
Perfect. Thank you, Labisa. And are contract employees entitled to vacation pay?
Contractors, I think maybe the question might be, are contractors entitled, like independent contractors?
So it's either that, or is it maybe referring to fixed fee or fixed term contracts, like employees on a fixed term contract? I'm not sure. We could answer it either way.
Either way, okay. So if it's an independent contractor, then no, because independent contractors fall outside of the realm of employees. They're essentially meant to be a business within your business. And as such, they're not entitled to the protections of the minimum standards legislation in each province and federally. So the answer would be no on that front. But if you do have an employer-employee relationship, regardless of how long that contract is for, you still have to abide by the minimum standards. You still have to give vacation time and vacation pay in accordance with those minimums.
Thank you. And is vacation pay payable during a probationary period, or let's say a 3-month probation?
Yes. That's it.
Don't you love a straight answer?
I love it. Yes, absolutely, for sure. And
there's
then
nothing more. That's it. Yes.
Our last question. So when you say that terminating an employee before the end date of the contract can result in employer having to pay out the remainder of the term, is it because the contract does not have an appropriate termination clause?
Yes, correct. So what happens is, in a fixed term contract, just like with any other contract, you try and make a provision for termination. So you try and put a mechanism in place for how much you owe that employee upon termination. But just like with other contracts, employment agreements, there are so many ways to mess it up that it can be really detrimental. And so when it is messed up, when the termination provision isn't valid for some reason or other, it makes it so that really there is no mechanism for termination anymore. And what that ultimately results in is a breach of the agreement if you try and terminate it before the end of the agreement. And the result of that breach is that the employer has to pay out the damages, which are the remainder of the contract. So that's what the employee is losing out on by the employer having breached the agreement. So that's why that payout needs to happen.
And just to piggyback on that,
Yeah.
It's a fixed term agreement is different than an open-ended agreement in the sense that the damages are kind of, they're set in place already. So you don't have to go to a common law determination using the Bardell factors to figure out how many months the person's entitled to. Essentially, unless you have a proper termination clause in place, the person's entitled to the remainder of the contract. So, that could be as we saw in that case, that could be an enormous amount of money to pay someone to not work for you. And you see that happening all the time in the real world with, like coaches and who get fired like 2 years into their, look at the National Hockey League or the NBA or any of these professional sports leagues. They'll hire a coach. They'll say, we're going to pay you $5 million a year. And then the team does terribly and they want to get rid of the coach a year and a half later. So they're now paying this coach to sit home at the tune of $5 million a year for the rest of those 5 years. So careful with these fixed term contracts.
That's a very good analogy. Anatoly, yeah. I know I'm still cursing at Claude Julien in Montreal because I'm a Habs fan. So it's, he's still on the payroll. So
there you go.
But that's good. So I don't think we have any other questions.
Amazing.
So thank you all for joining the webinar today. Thank you for staying extra for the extra overtime as well. So definitely appreciate that. And Anatoly, Lubisa, thank you for being so fantastic and sharing so much good information with our participants today.
Yeah, our pleasure. Thank you
Thank
to
you
everyone
so
for
much.
joining us. It was a real treat.
Take care, everyone.